The Honorable Supreme Court, in its historic judgment on electoral bonds, declaring it unconstitutional, has emphasized certain principles which we need to take note of, because these principles have universal relevance. The first is doctrine of necessity and proportion, that in furtherance of any objective to accomplish any goal and purpose, if the government chooses any course of action or government deploys any set of means, that must conform to the requirement of necessity and proportion. Your action should not be disproportionate to the gravity of the problem you are willing to address. So if you want to bring transparency in the political funding in India, if you want to cleanse the system of political funding in India, so fine, you can choose the system of electoral bonds. There is nothing wrong with that. But the manner in which electoral bonds, were being operated, it is something which was questioned by the Supreme Court. Before the introduction of electoral bonds scheme in 2018, in 2017 budget through Finance Act, the Finance Minister had already amended. If the Parliament was made to amend three laws: Companies Act 2013, then Representation of People Act 1951, and Income Tax Act 1961. What was the final outcome of these amendments? Final outcome was this: that the political parties were largely exempted from the liability of disclosing the identity of the donors to the political party above 20,000 rupees something. And then Income Tax Act, in Income Tax 1961, which was amended. What was the consequence? The consequence was like the political parties were exempted from the necessity to maintain complete records of the donors, their name, their address, whatever amount the political parties were supposed to get through the electoral bonds. And the Companies Act amendments were made to ensure that the companies were made almost free to make an unlimited amount of unlimited contribution to the political parties through electoral bonds, and they were not required to disclose the name of the political party, the name of the beneficiary they were giving money to, and they were also exempted from some kind of formalities. So the consequence of Companies, and one more thing, the Companies Act 2013, which was amended, and one of the consequences was this: that there was no scrutiny. There was no provision for the scrutiny of the company which was making the contribution to political parties, whether that company is profit-making company or loss-making company. So that actually created the possibility of a loss-making company making contribution to political party in search of some kind of quid pro quo, give and take kind of arrangement. It means previously the political parties could get funds from the companies, but there was some restriction that a company could not donate to political parties more than 7.5% of their net average profit in the preceding 3 years. So there was a cap, there was a limit beyond which companies could not contribute, the money to the political parties. But after this amendment in Companies Act 2030 through Finance Act 2017, that regulation was done away with. So overall, the companies, they don't need to maintain such records. The name of the beneficiaries and how much amount they are, just disclosing the broader amount that they are donating to the party, but they were not supposed to make any declaration of identity. And the political parties were exempted from number of formalities pertaining to maintenance of records, pertaining to contribution coming from individuals and the corporate entities above 20,000 through electoral bonds. The consequence was this: that there was lack of transparency. So the common citizen, we enjoy right to information. Right to information is a part of freedom of speech and expression under Article 19. So on the one hand, our right to know, the citizens' right to know about the contributions being made to the political parties, the identity of the donors, and the amount of money given to the political party, and which political party is the beneficiary. So our right to know what is happening with that money, that right was in a way restricted. And on the other hand, as the government maintained that the right to informational privacy of donors was to be maintained, because those who are making donation to the political parties, they always had fear of political retribution. So that's why their right to privacy under Article 21 was to be maintained. So now you have two competing rights of the common citizen, Under Article 19, freedom of speech and expression, that also includes right to information. They have every right to know how much money is being donated to which political party, what is the quantum of that money, who is the beneficiary and entity of the donor. And on the other hand, you have the donors. They enjoy fundamental right under Article 21, right to life and personal liberty. That also includes right to privacy. Right to privacy. So right to informational privacy, that we are not going to share whom we are giving money to. So right to privacy on the one hand and right to information on the other. So Article 19, Article 21, which one enjoys precedence? So in this kind of situation, to deal with, Supreme Court said that there is nothing like hierarchy of rights. One enjoys precedence over the other. But in the given situation, when you examine the context, it becomes amply clear that if you really want to bring transparency in the system of political funding in India, so you cannot cannot encroach upon the right to information of the citizenry.